My iPhone automatically prompts me with the alternative for okay to give a thumbs up emoji. It is synonymous, according to my iPhone, with okay. So, I think context is everything here. Hello, and welcome to another edition of Beneath the Law. My name's Gavin Ty. I'm here with my partner and friend, Stephen Teal. And
hello, Gavin.
Yeah, hello, Stephen. So, I was about to send you a big wavy hand, but we live in an age of pictograms in communication, with everybody communicating by text and not so much email anymore, but by text and other platforms. Pictures, speak 1,000 words, as they say, and cartoony pictures or emojis are how a lot of people communicate in our digital age. Who needs to learn how to spell when you've got a big fat smiley face? So
it's modern hieroglyphics.
Well, that's right, and we need the Rosetta Stone sometimes to figure them out, but. In this particular instance, we see the creep of emoji speak into the wild and wonderful world of exciting contract law, particularly the most exciting contract world of all when we talk about grain contracts and who could constrain themselves when thinking about these things. So a case that kind of drew, frankly, international headlines in the last little while came out of the province of Saskatchewan, where you might be shocked and amazed to find out that there were grain contracts in play. In this particular instance, it was flax seeds. And, one of the classic contracts, I suppose, is where the farmer or the producer agrees to sell the crop at a fixed price in the future. I mean, the Chicago Exchange, for example, was set up to take bets, for lack of a better word, on exactly that, on all sorts of commodities. So that's a big risk. There's a big play there when you're a farmer and or a buyer of agricultural products, and you're buying at the beginning of the season a crop to be produced and delivered at the end of the season, because a lot of things can happen, of course, in a season. So, for example, if it doesn't rain that year, that crop could be pretty valuable by the bushel because there may not be much of it. On the other hand, when there are bumper crops, it can be pretty cheap. So there's lots of play between the price going one way or the other, and therefore lots of cold feet, I expect, in terms of contracts and people trying to get out of them. So the case that this came out of was a case called Southwest Terminal Limited versus Archer Land. And in that case, the plaintiff was a buyer of flax seeds, and they sought summary judgment to enforce a contract that they said had been validly entered into for the supply of flax, not fax. These are the facts.
That's an old technology.
This is the facts
there,
about
Gavin.
the flax. So the way they undertook their business, which is not that unusual, I suppose, in this day and age, is that there was a contract flipped over to the producer, terms and conditions, the big one probably being price, and producer responded with a thumbs up emoji. And the question for the court was, is that a contract? Was there, I think just narrowing it down for our listeners, I mean, the lawyers out there, sorry about this, but the three key elements of any contract are offer, acceptance, and consideration. Consideration was not an issue here. The question was the thumbs up emoji sufficient evidence of acceptance of the terms of the agreement such that a valid and binding contract was in place and that the producer was obligated to deliver at the price set out in the agreement?
That's the nutshell of that case. You explain the Chicago Exchange. It reminds me of the movie Trading Places in a way, with respect to the oranges and the hedging on that. But a very interesting case, Gavin, because of the modern use of emojis. to signify things in that created a binding contract. You have that text message that's sent and the thumbs up emoji being sent back, and the court looking at this. Now, the defendant basically had argued before the court that the thumbs up was merely an indication that they had received the contract, and the court basically ruled the other way and said, no, that was an indication that you had accepted the contract. What I find, specific to this case was that there was a long-term relationship between the buyer and the supplier, and that may have influenced the court's decision with respect to finding that the thumbs up emoji did signify acceptance of the offer, because they had dealt with one another for, 10 years or more via text messages or other forms with respect to their contract. And the buyer had always given a very curt response, and there were never any issues with respect to the supply of flax or other grains, and that they had entered contracts in a very, very similar fashion. So in some respects, while, as you said, this case has, I think, garnered some international attention, it also may be narrow in some respects because, as we know, the law of contracts is built in terms of interpreting when a contract is entered, some surrounding circumstances and the overall custom of usage, as well, sometimes between parties or within specific industries. And I think those factors, the length of the relationship and the way that contracts had been entered before, this one being the first time that an emoji was used, was particularly influential in the court's decision.
Yeah, I mean, I think your point is, and I think this is important as well, while this may seem like some sort of earth-shattering and groundbreaking decision, there's nothing new here. The court in the Saskatchewan case looked at the things that a court should look at when dealing with an interpretation of a contract, and that was directed by our Supreme Court of Canada in a case called SATFA, which is that they look at all of the surrounding circumstances in interpreting whether the contract was valid or not. In this particular instance, there had been a long history between these parties of buying and selling grain, and in years gone by, there had been the assent of the supplier with words like yup, like Y-U-P, or looks good, or okay, and that was enough, and the contract had been performed. Also importantly, obviously, there were more terms to the agreement than that, and in this instance, what they did and always done is flipped over the standard form agreement, which the court referred to as boilerplate, which never changed, and was the same one used in the Emoji contract. And the assent was given by the words okay or yup. Now, interestingly, the evidence in the case indicated that the emoji was sent from an iPhone. And just curiously, before we came on to do a recording today, checked out my own phone. My iPhone automatically prompts me with the alternative for okay to give a thumbs up emoji. It is synonymous, according to my iPhone, with okay. So, I think context is everything here. And I don't think that there's anything particularly unusual about the case other than it made for a kind of a cute little pictogram, as you put it, for media to pick up on. But the question for the court was there evidence of consent to the terms and conditions of the agreement? And the court found that in the context of the commercial relationship between the parties established over many years, that the emoji was certainly as good as an okay.
Yeah, for sure. And, as we become more and more modern, or as technology influences our lives more and more, I think we're going to see an increase in cases like this one. You mentioned in terms of the iPhone automatically populating the word okay, or with the suggestion of using the thumbs up emoji. That was important to the court. That was basically the accepted definition of the thumbs up emoji. And, when you interpret contracts in law, you can certainly rely upon dictionary definitions. And this one, I guess, being an online definition of what was most commonly meant by the thumbs up emoji as influencing the case. The other interesting thing, and we've had this question fairly recently as well, is creating a contract through electronic means, and just clicking on a box on a let's say a fitness membership to waive your risks and liabilities for if something happens to you while you're working out at the gym. You click on that waiver. That constitutes a valid signification of an agreement without any words. It's just the click in the box. So legislation has certainly been implemented in most provinces. Saskatchewan has the Electronic Information and Documents Act. Other provinces have similar legislation that permit a contract to be entered into electronically. And certainly in this case as well, from a contracts law perspective, the boring contracts law, you don't need to necessarily sign an agreement to enter into a contract. Right, a series of email exchanges or text message exchanges can signify a valid offer and acceptance of a contract. But, looking at this a little bit more closely, Gavin, I came across a bunch of other cases that have had very similar results in the court. So this is, we thought it was a groundbreaking case. Maybe it is for Canada, but they've been dealing with cases like this in Israel and the United States for a number of years now.
Yeah, for sure. And in the Israeli case, it was basically they were communicating by emoji in terms of renting an apartment, and the landlord apparently relying on the very positive emojis from the prospective tenant took the apartment off the market, and the court found no, you gave that representation via emoji to the landlord for the purposes of it being relied upon, and therefore you're responsible for it. That's interesting. I mean, it's an interesting question. I think about this. I mean, I know another case in British Columbia. I don't know if you're familiar with this case, a case called Johal, but that case similarly dealt with the automatically populated email signature being sufficient as an acknowledgement of acceptance, or in this particular case, it was acknowledgement of a debt, which in British Columbia law extended the limitation period to sue on that debt. So it was good enough that you sent an email with your automatic signature on it to acknowledge the fact that you owed the money and thereby prolong the limitation period. I think that this is a bigger issue here. And as I thought about all of this, I was thinking about this in more of a societal aspect. And, oftentimes we talk about things about how things have changed and the pace of change and how quickly things have changed. It wasn't that long ago when with great flourish and fanfare, you'd pull out the red seals and pour wax or put your signet ring on an agreement to show it was signed under seal, and all these great formalities. And I think we cluck and laugh at that a bit in our digital age. But maybe there's something to that. Maybe that formality, or that take out the quill pen and have 5 witnesses to the signature. Maybe there's a moment of cold, sober second thought and reflection that you've actually considered the terms of the agreement. And I have to confess, I've been practicing law for 30 years. I mean, I don't know anyone that actually reads the terms and conditions of an online agreement when they're clicking. Like, for example, when you download an app, do you agree to the terms and conditions? Everybody just clicks it. Nobody reads it. there's no and to going back to our Latin law school. There's no consensus ad idem in the sense of a meeting of the minds. I have no idea what I'm agreeing to. Maybe a little bit of formality in contracts is not a bad idea.
Well, so, certainly consumers have protections under consumer protection legislation with respect to entering, standard form contracts on the spot, because you're right. Look, most people don't read them. And the print is so small that you can't read it anyway. But commercial contracts, certainly, they're serious agreements and they should have more formality, I suppose. But here we are. People are dealing with each other in a much more informal way nowadays. And what one person believed was their intent with respect to answering back a text message with a thumbs up emoji proved wrong.
I don't think the court believed them, to be honest. I think that what happened was, the reality was, they were perfectly happy with the deal in the spring, and then the price moved against them by the fall, and they didn't want to do it. So and look, it raises. I had a client years ago who said something to me which has always stuck with me in terms of contracts, and they said, contracts only matter when people break them. And truer words have actually never been spoken. If everybody did what they said they were going to do, you wouldn't need any contracts. You probably wouldn't need any lawyers. It's only when people don't do what they had agreed to do that the contract ever is probably pulled out of the dusty drawer and read. Often, I would have to confess, for a lot of people, for the first time, as to what did I actually agree to? And then they're looking at it in hindsight and saying, boy, I wish that was different.
Oh, I don't disagree with that, but Gavin, I think people have to be very careful in how they use emojis, because different
the
people.
Informality of it. That's the point. It's so easy now to agree. It's so easy to click. It's so much easier, for example, when you're downloading an app, to just click it and say yes. Saying yes is the path of least resistance in online contracts. But be careful, because they are contracts and they will be enforced.
Right, but at the same time, people need to be careful, because different cultures use emojis, or emojis mean different things to different people. Which is interesting, right? It's part of this Israeli case talks about Chinese people mean something different when they send you an emoji.
Oh, okay, sure. I mean, interpretation of language is important. I mean, if emojis are the new emerging universal language, which is an interesting point, because they do transcend all written or spoken language. Everybody understands, I think, what a smiley face means, or maybe they don't. But are we going to have an emoji dictionary? That's
perhaps. We seem to have it online.
Yeah, well, that's right, and an emoji dictionary in context, because you could have sarcastic emojis, for example.
That's how archaeologists make their money when they're reading Egyptian pictographs.
Yeah, I come back to we need the Rosetta Stone for emojis.
But, Gavin, it's just not, it's not confined to contract law, right? There's now a case before the courts in the United States, which is basically a securities fraud case in some respects, or a material misrepresentation case over a investor, a well-renowned investor, sending out an emoji with respect to buying Bed and Bath & Beyond stock. What was it? The moon emoji, which is now part of a lawsuit, because that was an indication to potential investors that, take me to the moon. This is a stock that I should be buying. And then it turned out that the investor, the person who sent out this text message with that moon emoji, smiling moon emoji, actually sold his stock. Bed and Bath & Beyond tanked, right? He made $68 million left other investors holding the bag, and now the company is bankrupt.
Yeah, the old pump and dump by Emoji. So yeah, those types. I mean, it is a way of communication. I think that anyone who thinks that, despite the way it looks, that it will not be taken seriously by the courts is mistaken. We may be chuckling about the medium and the message here, but these are real issues. And in the I think it was Ryan Cohn was the investor you're talking about. In that case, I mean, real people lost real money. I mean, this is serious. This is serious stuff in terms of real people, losing their life savings because of an emoji. It sounds kind of funny, but that's real pain that caused real harm. And I think people need to be aware of the fact that while there is a great informality in clicking the emoji, that it can have real impacts later on not only yourself in terms of a contract being enforced, like our flaxseed case, but on other people as well. And that's the world we live in.
Yeah, no, it's. I'm just was reading the decision of the court from Washington, and it really stands out. This is the judge's, direct quote from the judgment. Emojis can be actionable if they communicate an idea that would otherwise be actionable. A fraudster may not escape liability simply because he used an emoji. Just like words, liability will turn on the emoji's particular meaning and context. So people really need to be careful, when they're communicating with one another and then adding an emoji. I mean, people will interpret that very differently. And the last thing that you want is for a court to decide what that necessarily actually means. And
although this is a purely audio podcast, let me say that I've got a big thumbs up emoji for that last comment, and punctuated by several smiley faces. So once again, thank you all very much for taking the time to listen to this episode of Beneath the Law. We hope that you will follow us. Please give us a rating on your platform of choice. Please send us,
including thumbs up emojis.
Yeah, we take thumbs up emojis with glee, and they will get smiley faces in return. Please do listen again. Thank you so much for your time and for listening. And please send us any comments, concerns, and or suggestions of how we can make this better, or topics that you'd like us to chat on in the future. Really appreciate any feedback. So, Stephen, once again, I'm going to do our little tagline, but if no one is above the law, then everyone is beneath it.